This is Colin O'Keefe here for LXBN TV. King.com, the publisher of popular iPhone game Candy Crush, has long been at the center of IP law issues, including their recent efforts to trademark the word candy and allegations that they stole another company's game. Joining me now to discuss each story from Nashville is attorney Kevin Hartley. He is with Stites and Harbison, and he is also author on the firm's excellent blog, Trademarkology. Kevin, first, as King has recently abandoned its efforts to trademark the word candy because of the difficulties that have come with the process, what advice would you have for them as far as making their product a little bit more trademark friendly?
Well, Colin, I'll start by noting that they did do what we would recommend, which is went out and got trademarks for Candy Crush and Candy Crush Saga. They have a number of registered trademarks related to the full title of the game, but their more recent efforts were to just get the word candy. And if they wanted a one-word name, something like, say, Apple, something that's maybe a little bit easier to pitch or easier to place within some sort of product placement scheme, what they really should have done is picked a word that was less descriptive of what their game is and less generic, as we'll often say. There's a whole distinctiveness spectrum within the trademark world, and the more descriptive, more generic your mark is, the less strength it has. And just using a word like candy to describe a game that prominently features candy doesn't quite get you over that hump to a place where it's easily protectable. If they had chosen a fanciful term, as we'll call it, a term where they just made up a word, potentially, maybe combined sugar and candy in some way to create a new word and made that the name of their game, then they certainly could have pursued, and I'm sure gotten trademark protection for that word, and it probably would have been a relatively strong trademark.
I see. And then second, King has developed a bit of a reputation as being a bully, and that goes beyond these recent trademark efforts on the word candy, and also to their attempt or alleged attempts to steal another developer's game. When it comes to small companies with these games, what advice would you have for them to protect their products to make sure that another bigger company doesn't come along and steal all the profits?
I think the most important thing that a small company can do to protect itself is to go out and pursue protection for its intellectual property. And in the case you are discussing with Candy Crusher and Candy Swipe, the small company, they did do that. They went out and they got a trademark. So that's the number one thing I would recommend certainly to do as part of your brand building. Get a trademark. If a patent's appropriate, maybe go pursue a patent. But the number two thing behind protecting your intellectual property that I think is most important is to be the first to the market. Be the first to the market, be original, and get your IP protection. Now, as with the Candy Crush case, sometimes that's not enough for small companies. And so what I would say is not only do you have to be first to the market and protect that IP, but then, make sure you back up your investment. It may be tough at first, but you've got to go out, you've got to market your product, you've got to get it out there, you've got to make people aware. And if you're first and people become aware of you first, you can, a lot of times have the upper hand. The quick example would be the Snuggie. The Snuggie comes out and they have this novel idea and they're first, they're original, and people love it, and they got it out there and it got lots of exposure, and you saw behind that came things like the Slanket and other knockoffs, but they weren't first. And even though it's the exact same product and there was very little that Snuggie could do to keep them out of the market, because they were first and they were original, they succeeded. And if you have a game and you get it out there, you've got to make sure that you're really pushing it, you're pushing it hard so people know what it is, and they know that Candy Swipe is the game and that Candy Crush is the knockoff. And that didn't happen here. That game didn't get enough exposure, and a larger company like Candy Crush was able to come in and take advantage.
Definitely. It's an interesting situation because though it seems the smaller companies have done all they could to protect themselves and their products, there's always more that they could do to protect their intellectual property. Once again, that was attorney Kevin Hartley. He is with Stites and Harbison in Nashville. For more of his insight and for commentary from his colleagues as well, be sure to check out its excellent blog, its Trademarkology, and you can find it at trademarkologist.com. Thank you for joining me today, Kevin.
Absolutely. Thanks for having me.